Hello, everybody. Welcome to the Lawyer Show today. My name is Jeremy Rosenthal, and I am your lawyer. And that's okay. This is Morgan McPheeters. She's my co-counsel today. And today for the Lawyer Show, we're going to talk about appeals. As you can see, I am not in my customary lawyer outfit or costume today. I am wearing my COVID-19 lawyer apparel, which is frankly kind of what I've worn every day for about the past year. I've always wanted to. I try my best every week on the Lawyer Show to wear my suits because that's how a lawyer ought to look, right? And so today though I'm doing a dressed down version of this. I would tell you that it's intentional, but the fact is that I realized that I didn't wear my suit, and we had the Lawyer Show today, probably sometime around 10 or 11:30. The good news is I have a Zoom suit in my office, and so when we have to go to court, we wear our Zoom suits. But just an introduction briefly to the Lawyer Show. It's a show for lawyers, about lawyers, for non-lawyers who are curious about seeing what and how lawyers think and what we do. And some of the soul-crushing things that we do, whether or not whether we're sociopaths or not. These are for you to judge as the audience, and you can tell and watch us and see exactly what it is you think about it. I will tell you too that part of the reason that I do the Lawyer Show, not only to enlighten all of the viewers out there, but it's also for the reason that I haven't been in trial in over a year, which is very, very rare for me. Now, another thing about lawyers that I think everybody needs to understand is that lawyers are we have to brag a lot about ourselves, and there's a lot of I don't know if I'm going to pronounce this right, aggrandization.
Yeah, that sounds right.
Okay. There's a lot of that, and what I noticed when I graduated law school, and maybe Morgan can attest to this, what I noticed when I graduated law school is that there's a lot of lawyers who have to tell you, there are a lot of name dropping, first off, a lot of name dropping, and that's very important in practicing law. It's also very important to tell people how long you've been practicing law. And that's also an indicator of and I don't know what it's an indicator of, but and I find now that I've been licensed 20 years, that I can now say I've been licensed 20 years. And that and so I anticipate that the name dropping, the years of practice, and the amount of push-ups I can do, lawyer push-ups, okay, it is only going to increase. And so in this show, I hope that everybody at home, I hope that we can show everybody at home that we're going to be big name droppers. We're going to talk a lot about the push-ups we can do and a lot about our achievements that we've made, because that's kind of what lawyering is all about, right? It's about that stuff. Now, my guest today, Morgan McPheeters, I do want to talk about this because Morgan has, now I don't see age. And I don't see, I don't see age. Okay?
I'm scared where this is going.
Well, okay. My point is that Morgan does not have to talk about how long she's been practicing, for the reason that Morgan has accomplished quite a lot, probably in not a long time. Morgan has argued multiple cases in front of the Texas Supreme Court. She and I have, well, I say she and I, she has worked on cases and taking cases that I have worked on as well. I would say that we did them together. She was the one that went in front of the Texas Supreme Court and won the thing, and I got my name on it at some point.
Yeah, sure. And you laid all the groundwork. I just finished it out.
Yeah, you did. I did. Yeah, we'll tell the story here.
Yeah. It's a good one.
We'll tell the story here. But yes, I mean, so that would be like my part of it, the legal, well, yeah, I just don't want to get too ahead of our skis here, because we do have a lot to cover here. But Morgan is an appellate lawyer, and again, she has accomplished a whole ton in not a lot of time. And so while lawyers like me have to go and continually say things like, I've been practicing 20 years and I know old judge, blah, 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 you know. While I have to do things like that, Morgan really doesn't. She's actually, you know, I'm all hat, no cattle. She's all hat and cattle.
Stylish and got the stuff to back it up is what you're saying.
Yes.
Okay.
Yes. Okay, so introduce yourself. Introduce yourself to our legions of fan, singular.
All of our viewer. Hi, I'm Morgan McPheeters. I'm an appellate lawyer, sometimes known as a book lawyer. I like to think I'm a little bit more than that. Although appellate lawyers, we normally do have a reputation for being a little bit nerdy, a little bit introverted. I'm not that way. I'm not a regular appellate lawyer. I'm a cool appellate lawyer. But yeah, so I practice here in Dallas. I grew up in New Mexico, came over to Texas for law school, and have been here ever since. Started saying y'all the second I got here because it's the best word ever.
Well, you are you went to New Mexico State University.
Yeah,
Their mascot are the Aggies,
correct.
and I consider them to be the real Aggies.
Ooh, shots fired. Shots fired. You know, I'll say I prefer that kind of Aggie to the other kind of Aggie in Texas. No offense, I have a lot of Aggies in my life. I love them dearly, but
Well, let's talk about what's wrong with them.
no, let's not.
We've got Heidi, who's my office manager. She's sitting 12 feet that way, and Heidi is she's a fighting Texas Aggie. And but no, seriously, what's wrong with them? Let's start there.
Oh gosh. Nothing is wrong with them, but they're very passionate about being Aggies.
About football.
Yeah. And you have the core. It's very intensive. It's, I don't know. I don't want to offend anyone.
The lawyer show is about, look, we're showing people that we don't have feelings and that we don't care and that we will.
See, but I have a lot of feelings. I'm like a bleeding heart lawyer.
Okay, this is where being licensed 20 years. See, I would say I started showing signs of being a sociopath 10, 12, 15 years in.
Okay.
All right. And I mean, maybe that's just, maybe I'll check back with you in 30 years and we'll see if I'm a little bit more dead inside at that point. That's right. That's right. Just chasing the wallets and trying to, we'll work on this with you about trying to capitalize on people's miseries. So were you born and raised in Cruces? Is that right?
No. So actually, I was born in Salt Lake City, Utah.
Okay.
And moved to Farmington, New Mexico when I was very, very little.
You told me this before. Okay.
So Farmington is in the Four Corners area of New Mexico. So like if you've ever been to Durango, Colorado, it's like 40 minutes from there. So I grew up skiing in Durango and Colorado all the time. Then I went to NMSU, which is in Las Cruces, for undergrad. Just, right there by the border, right by El Paso. Mm-hmm. Amazing, incredible food. I miss the food of New Mexico so bad. Let's get into it. Let's talk about Aggies. Let's talk about how Tex-Mex isn't as good.
It's a different type. It's chili and
yep.
Yeah.
Yeah, the chili based, it's totally different. I had an uncle who married into our family, came to visit New Mexico for the first time and ordered a bowl of chili off the menu at a little restaurant that we went to, and the server was just so confused, like that's it, that's all you want is just chili. We had to explain to him it was not going to be Texas chili mm-hmm. with meat and may or may not have beans depending on where you fall on that issue. But yeah, it's totally different, but it's so good.
Yeah, we had this talk before too, I think. And man, I forgot the name of the restaurant, but we went this last summer to New Mexico, and we went to a restaurant in Albuquerque, and it was just, man, a meal's really good when you're reminiscing about like a lunch you had back in July, in the following February, and it was an open face hamburger with chili on top with the green hatch chilies. and I think guacamole and a little bit of probably some sour cream mixed in there.
Nice. Yeah, that sounds good.
Yes.
Green chili is where it's at. I don't know how in the weeds we want to get on green chili, red chili of New Mexico, but I'm definitely team green chili. That's the state question of New Mexico is red or green. And then if you want to mix it up, you can just say Christmas and you get both.
Well, so. and Heidi's feeling good because we're not beating up on the Aggies anymore. We haven't forgotten about them.
We'll circle back.
We'll circle back. We're going to get to that. So you went to New Mexico State, and then you came to Baylor for law school.
Yes.
Okay.
Oh, gosh.
What's so funny?
Here we go. I've watched your show, Jeremy. I know how you feel about Baylor.
I love Baylor. Look, I pay more money to Baylor lawyers to get me, for my legal issues. So I feel like I can kind of make fun, but okay. So we talk a lot on the lawyer show about practice court.
Yes.
Okay, and I think we actually last week was Snowvid. This week is, and the week before that we had Sharon Ramage, who is a Baylor lawyer, and we very briefly discussed practice court. But tell JP, Kathy, and the Crew Nation what practice court is.
So practice court is unique to Baylor. It's their pride and joy. It's what gives Baylor the reputation of being the Marine Corps of law schools. And it is, in other law schools, from what I've heard, first year is really the hardest. That's where they're really going to knock you down and see if you've got what it takes. And then by the time you get to third year, you're kind of
financially
just coasting.
or
both.
Okay.
Just both. By third year, though, it's a bit more of a coast. But Baylor, first year's tough. Second year, a little bit easier. Let up on it a little bit. Third year, though, is when you start practice court. So practice court is an intensive program. It's 2 quarters long because Baylor's on the quarter system. We're special in so many ways.
Just ask them and they'll tell you.
We'll tell you. So practice court, 2 quarters long. It is intensive procedure and practical training. And you go through several mini trials that you try from start to finish. And then you have a big trial that kind of culminates the whole program.
Are these all civil trials?
So for the most part. I think in recent years they've kind of expanded to offer a handful of criminal options. They're adding in commercial stuff, a little bit, broader in terms of the types of cases. But I think most or all of them are real cases that they've sort of sanitized and repackaged. But the thing about it is that you are doing a case from start to finish. So you're drafting the pleadings, you take depositions, you do a summary judgment hearing, you deal with expert challenges, you do voir dire, and then you do a whole trial, the whole works, charge conference, settlement conference, and then post-judgment
Are you allowed to
motions.
settle the case?
So you
like,
sort of are.
Sorry, you tell your professor second week, we settled.
Peace out. Well, actually, I am the proud creator or the inspiration for a rule in practice court as to what you are not allowed to settle. Our case, we reached an agreement on liability, and we tried our case on damages only. And our professor was not very pleased that we did it that way, although it didn't super change what we had to do to prep, but I'm told that he promptly went back upstairs to his office and added that into the practice court rules.
Well, that's congratulations. That's hard. I mean, that's really hard to move the needle.
Yeah.
On something like that.
Proud of it.
Congratulations. Yeah. So, okay, now, and talking about practice court here. So, can you play mind games? I mean, are there? I mean, to what can we? Can you like Professor so-and-so, can I'd like to jam this other guy's fax machine. Can we do things like that? Because that's what happens in the real world.
Well, I think that there's always going to be some folks like that, just like there are in the real world. I wouldn't say that's the norm. At least my experience, we were pretty friendly. It was fine. We got into a little hiccups here and there, but it was mostly fine. Our case was interesting, though. We tried the Branch Davidian case. And so my practice court partner and I...
Another special thing about Waco.
Oh, yes. Ugh.
They just keep coming.
I know. They're happy now, though, because they have Magnolia that's sort of distracted from maybe
Chip and Joanna.
Yep, Chip and JoJo.
Mm-hmm.
They've done a great job of, revitalizing things. But our case, my partner and I, we represented an injured ATF agent. They were injured in the raid on the Branch Davidian compound, a real person who's out there today. You can look him up on LinkedIn. But we, in this pretend case that's based on a real case, we sued the media companies who allegedly, tipped off the compound that the ATF was coming, thereby causing everything that came after that. So really, really fascinating stuff.
Yeah, that would be an interesting issue, I would think, because you've got First Amendment issues, right? And then you've got, was this in federal court or was this in state court?
It was state court.
State court, okay.
Yeah.
Did your judge, and so as part of practice court, does the judge know what they're doing, or is it like sometimes real court where the judge's like, I hadn't read any of this, and we'll just split this down the middle, and is that how it happens too?
So most of the time, your judge in your big trial is another practice court student, and it's part of something that you're responsible for doing. So as students in the program, you might be on a jury in one case, you might be a judge in another. So it's all responsibilities that you have. So probably for the most part, they're not going to be as prepped on the issues. But then you have an observer who is a practicing lawyer, trial lawyer, who will watch and give feedback. In our big trial, our observer was Professor Jerry Powell, who is the practice court professor. And everyone kind of hopes that they get a practicing trial lawyer who might go a little bit easier on you. Professor Powell certainly did not go easy on us, but I admire him a lot. It was a great experience. But
so, are you allowed to grant summary judgment? Then I guess not either. I guess.
Well, you can, but the case is still going to go to trial. So that's the fiction of it. Is like we'll just keep going. Although we did settle while the jury was out, we settled with one of our defendants, and thankfully we did because if I remember right, when the jury came back, they had zeroed them out. So
this is really like a Texas jury too.
Yeah.
Okay, yeah. Real in so many ways. Okay, so one of the reasons I give practice court folks so much of a hard time is because and we'll have an honest talk about it. We'll have an honest we'll have an open, friendly debate.
Okay.
About this. Okay, because for the reason for a couple reasons, and I think some serious reasons too. Number one is that Baylor as a law school, and they can take this for what they, they don't need to know from Jeremy, right? They don't care.
I'm sure they're waiting. They're watching this live. They want to know.
Perhaps. Baylor students are extremely talented. They accept students that have exceptionally high LSAT scores. Right. Baylor is as far as law school goes, is extraordinarily strong academically. And my thought is that there's other schools in the state that I won't name by name, but there's other schools in the state that are not nearly as that are just that have a student body and that is going to have to practice law on day one. There's what do we have? 9 accredited schools, 10 accredited schools?
I can't remember.
Yeah. Because I don't know if what is it? North Texas has a law school now, and I don't know if they're accredited.
I think they are.
Okay.
I think they are. Yeah.
So that would make 10 accredited law schools in the state of Texas, and of those 10. And maybe that's a good example. Maybe North Texas law is a good example. People who go there probably have to figure out how to practice law day one because they're not going to get necessarily really strong jobs. They're not going to have, in many instances, professional mentors who can take them under the wing. These are people who are going to have to go. They're going to have to find the pond and fish on their own on day one. And I
because
just
it's newer, you think there's fewer alumni to draw on for connections, or
Baylor kids get jobs.
yeah,
Baylor's a good law school, and depending on the economy, Baylor kids get jobs, UT kids get jobs, U of H kids get jobs. SMU has a very strong alumni network, and they get a lot of jobs. Again, the economy notwithstanding. But to my point is that I don't think Baylor. I could be wrong, but I don't think they struggle in employing students. So in other words, they have a whole system of practice court that gets somebody ready. You're watching JP Cathy and the Crew network. You can watch JP Cathy and the Crew between 7:30 and 9 Monday, Wednesday, Friday. This is the Lawyer Show. You can watch us between noon and 1 on Thursdays. I'm drilling at the moment Morgan McPheeters. We're talking about practice court at Baylor, but she's an appellate law guru. But my point is that Baylor as a law school is they don't have to teach people, in my view, to practice on day one, because students like you go out and you get good jobs at good law firms who are going to have plenty of mentorship. And they're not going to make you do a summary judgment on day one. And you're not going to have a civil litigation trial on day one.
Well, it just depends on where you go. I mean, I was lucky enough to land somewhere where if you brief it, you argue it.
Mm-hmm.
And so I very quickly was jumping in and handling appellate oral arguments and summary judgment hearings. I have classmates who landed at much larger firms, big law firms, where, as I understand it, there's a lot of doc review. There's a lot more of the culture of the partner is going to argue it. They're going to show up in court. So I think it varies kind of wildly depending on where you end up.
And maybe the way for me to kind of say this better is I would rather see some of the schools that struggle in employing lawyers. They're the ones who need to have a practice court type situations, and those are the schools that are teaching their students whether or not the tax code has a soul, right? They're teaching a lot more of the theoretical things,
Yeah.
but their students their students aren't going to go out and be Supreme Court justices. Their students are going to have to go learn how to fight it out at the courthouse on day one. And so I would like to see other schools that have more of a practice-oriented thing. And the flip end of it, too, is that and of course, I've known enough Baylor people who say to me, "Well, we took practice court, so we're good. We don't need any help." Now, my second thing is my other kind of the burr in my saddle, so to speak, is Tarrant County, practicing in Tarrant County. That's a whole other. You do much in Tarrant?
Yeah, every once in a while.
Okay, it's
I
the
get over
friendliest place in the world to practice. Do they say that every time you're there? Have they made that clear to you?
I don't know. I don't know about that. I don't
These
know
are just
that.
my hang-ups.
Okay. Yeah, I think they don't love Dallas lawyers as much over there when I show up. But
Like an inferiority complex?
something like that.
Mm-hmm.
Oh man.
No,
I don't know.
they like Tarrant County. What they do is they sit there and they beat you over the head with how friendly they are. Except guess what? They're really not. They're like everywhere else. The only difference is they break their arm patting themselves on the back about how friendly they are, which is true. They're extremely friendly in many instances.
So who is telling you this? Who is
All of them.
Really?
All of them.
Okay,
Every
'cause-
time I'm out there, all of them.
like the judges?
Yes.
See,
The
I mean,
court
I've had
reporters, the bailiff,
I've had good experiences out there, and there's really good judges out there. And I guess the trial lawyers that I've worked with in Tarrant County are awesome, and they are super friendly. So I guess there's truth to that.
until you start winning.
Yeah. I don't know. I've had some strange experiences in Tarrant County courts, but I think the lawyer that made the experience strange was not from there. So I can't say. I don't know.
Well, and it's not that it's the only thing that's strange about it to me is that they're the only ones who brag about being special, but they're not. They're just they're the same. Look, they're the same. I mean,
And this relates to Baylor How?
It doesn't. It's just my second. It's just these are we're going through my
Just
we're
your
going,
quibbles.
We're going through all my luggage today.
Okay.
And
This
all
is-
my lawyer luggage. So
Festivus has been postponed. We are airing the grievances now. Okay,
that's right.
got it.
We're going to get
Got
to
it.
your achievements here in a minute. But
Okay,
but,
that's what I came here for.
I know. You thought we were going to talk about you. No, we're okay. So but right. So Tarrant County. Just let me give them one more uppercut.
Okay,
And then
okay.
and then we'll leave this. But no, they're not bad. They're just the same.
Okay.
But everybody that you talk to over there is like, no, we're better. We're friendly here. Okay, so you have coffee in the docket room. That's nice. Now you're hooking my client up to electroshock therapy for being 2 minutes late. That really wouldn't happen anywhere else. But don't let that stop your narrative about being friendly. Anyway.
Okay. Well, see, but I what concerns me is that this was a list that started out as your quibbles with Baylor practice court. And we've now gotten to number 2 people who talk about how special they are, but they're not.
This Tarrant County.
Just Tarrant County.
Just Tarrant County. And
no
so
connection.
I always have to tell people it's the friendliest place in the universe to practice law.
Okay.
And you just put it to them like that.
All right.
But
I hadn't heard that, but
and there's a lot of Tarrant County lawyers I know and that I love. I've been in front of judges in Tarrant County who are exceptional, who are very good. I've dealt with prosecutors in Tarrant County who are very good in front of juries. And yes, they're friendly, but they're not any more friendly than anywhere else I've been. They're just not.
I guess I just haven't heard this
No?
the Tarrant County
Go
brand.
over
I
it.
haven't heard that. It's not on the sign when you drive into Tarrant County. Friendliest
Yeah.
place to practice law.
In the universe.
I haven't seen that.
Okay.
So maybe I just missed that sign. Next time I'll look for it.
So, okay. How many times have you argued now in front of the Texas Supreme Court?
3 times, twice during the pandemic.
I
So
didn't-
over
okay.
Zoom,
Okay.
which is an experience.
So, okay. So tell everybody this. First off, talk about what it takes to get a case to the Texas Supreme Court.
So there's a certain degree of luck that has nothing to do with you. A large degree of luck, probably.
Which you seem to have.
Well, 3 times is a lot.
I'm thinking the common denominator here is Morgan, not luck. But go ahead.
I don't know about that, but it's just worked out that cases I've had, they just make their way up there. So so the courts of appeals, they have to hear every case. There's not discretionary review at that level. The Texas Supreme Court is a court of discretionary review. So you have to first convince them to take your case, that there is some good reason beyond just mere error correction that warrants them taking a look at it. So, first stage of getting them to take a case is your petition for review, and they may or may not pluck it out of obscurity and ask for further briefing. They can just deny it outright without ever having a response from the other side. So your first step is convincing them to even look at it in the first place, and then you've got to survive merits briefing, and then, maybe they'll grant the petition and consider it. And so it's quite a process, and you just never know if they're going to pick up on some little, interesting issue that you have there. You try to make it seem as if your issue, it's more important than just the case at hand. It has to be something bigger to Texas law as a whole that's going to impact other litigants.
Mm-hmm. And okay, to let everybody who's not a lawyer kind of visualize this and understand it. So we have what we call trial courts, right? That's going to be what you think of on TV the vast majority of the time. That's going to be your judge, your jury, 2 tables, right? A witness stand, and then a lawyer hopefully crying and hopefully getting paid.
Crying, okay.
Making their closing argument, and then the jury comes back and says yes, no, maybe so, whatever.
Sure.
And then the appellate court is the next level, and everybody's got a right to an appeal.
Yes.
Okay.
Asterisk there, but yes.
Right. In the abstract, you have the right to appeal if you do everything correctly and your case, otherwise fits. You can appeal what happens there.
Yes.
What you're saying is that the next level, which is the Texas Supreme Court, at that level, they have discretion. In other words, they don't have to take your case if they don't want.
Exactly.
And so everybody else also understands when they're not looking for, oh my God, you really got screwed. What they're looking for is cases that have a broader impact on jurisprudence.
Mm-hmm. Yeah, exactly.
Okay.
And it's very similar to how the U.S. Supreme Court works. So they get thousands and thousands of they're called writs of certiorari. They're different name, same kind of concept. And so the odds of getting your case in front of the U.S. Supreme Court are just astronomical. That's really, really difficult to do. Of course,
and the Texas Supreme Court is friendlier, I'm assuming, because Tarrant County is within, right? That's okay. But okay. So the three cases that you've argued, have you gotten your rulings back on the two that you've argued during the pandemic?
Nope, still waiting on those. The one thing that's really great about the Texas Supreme Court is when they hear a case for oral argument, they are very good about getting their opinion out before they recess for that year. So if you've argued it, you will most likely, barring some exceptional circumstance, you'll probably hear and get your opinion back by like June or July, sometime in the summer. I forget the exact when their term ends. So I'm still waiting on those two. We'll see how that goes. I'm trying not to read the tea leaves and guess what they're gonna do, because it's always really hard to know. Even a lot of people want to know after argument, well, what do you think? How do you think it went? What do you think they're going to do? What does this question mean about this justice's mindset? And it's impossible to tell, because a lot of times you have somebody who's asking a lot of questions in a particular way. They seem to maybe be leaning a different way, but they might be playing devil's advocate. They might be trying to convince a colleague of some other point. They might be shoring up their position, and it is going to lean the way you want, but it's just impossible to know. So I try not to guess too much, or at least not tell people what my guesses are.
And it's like Clarence Thomas, like he asked like one question in 20 years or something like that.
Something
Is that
like
right?
that, yeah. And it was actually fairly recently that he broke his silence for the first time in a long time.
Yeah. Now, so did you do the and before I forget, just so everybody also understands, Texas has two Supreme Courts. One is what we call the Court of Criminal Appeals, which is the equivalent of the Texas Supreme Court.
Right.
And then there's a Texas Supreme Court.
Right. That handles civil stuff only.
But I want to say too that it's the Texas Supreme Court that manages practice of law. So with a lot of the pandemic rulings that have come out and edicts, those come from the Texas Supreme Court, not necessarily the Court of Criminal Appeals.
That's my understanding as well.
Okay.
They promulgate the rules. They've been issuing all the emergency orders, shifting things around as needed. Yeah, that's my understanding.
And in the criminal world, and I forget, you can make sure I get this right. In the criminal world, we call it a PDR, Petition for Discretionary Review. Is it a writ of
certiorari, I think.
One of those. I can see it spelled because I always wondered how to pronounce CERTIORI. I'd have to write it out.
I don't know.
Is it one of those, or is it a PDR for civil cases?
So, in civil cases, it's called a petition for review.
Petition for review.
Yeah.
Okay. And did you draft the petitions for reviews on the other two cases?
So, of the ones I've just recently argued, I drafted one of them. The other one, I came in at the merits briefing stage, so a little bit later in the process, and then handled the oral argument. The other one, I handled the petition for review and the merits briefing.
Can you talk about the issues in those cases?
Yeah. So the first case that I argued back in late October, it was just before the election, that is a case involving Chapter 95, which applies to injuries on the job, on like construction work sites, basically. And it's a question of statutory construction as to whether that higher elevated standard or burden of proof, rather, that applies in those instances by the statute applies in this particular case. And so I represent Two
It
workers.
hinges, the answer, so everybody knows, hinges on how much money you won from a big company. I'm showing my stripes. I'm kidding. That's not really the answer, or is it?
Who knows?
But go ahead.
Who knows?
Keep going.
So in that case, I represent two workers who were electrocuted on a job site, and they actually took that case to trial. They got a jury verdict, and now the company is arguing that a higher standard applies to them, meaning that they are less liable to injured workers in this context. The other case I argued this session is a case. It's a discovery dispute. So in personal injury cases, an injured plaintiff offers up evidence of medical expenses that they've incurred as a result of whatever injury happened. That's the basis of the lawsuit. And part of what a defense might be to that is that those expenses, those medical expenses, were either not reasonable, they were too expensive, or the cost was unreasonable, or the care that was provided was not necessary. So those are the two big defenses. And in trying to establish that defense, in this case, the defendants sought to discover from the plaintiff's treating physicians information about what they charge other patients under other contexts. So this was a patient who did not use health insurance, but in this case, these defendants want to discover from these non-party physicians and medical providers, hey, what do you accept for a patient who has Blue Cross Blue Shield or Aetna or Medicare, Medicaid, workers' comp? And they want to use those numbers to show somehow that the charges that the plaintiff actually did incur for their bills in this case are unreasonable. Mm-hmm. So I represent in that case the medical providers who are resisting that discovery and trying to show that these other hypothetical rates wouldn't really apply to this person, so they're irrelevant to the case as a whole.
That would be like me in a criminal case arguing that, okay, so we stole $100 worth of things, but we could have bought, and that makes it a Class B misdemeanor. It makes it a higher charge once we cross that $100 threshold. But I can buy that stuff down the street for $90.
Yeah.
Right?
Yeah, that's sort of similar.
That's kind of what they're, and by the way, the case law says that doesn't work. Okay.
Good to know. That's interesting.
So yeah, but really, I mean, that's a very similar. That's a very similar issue because and so everybody knows, your practice is predominantly plaintiff. You work with lawyers, with plaintiff lawyers who are bringing civil lawsuits, right?
Yes. So for the most part, I do handle the occasional commercial appeal or a family law appeal or some kind of one-off like that. For the most part, though, I do mostly handle personal injury cases and on the plaintiff's side. So a big part of my practice is handling appeals, like we talked about, the levels above the trial court and beyond. And that's its own thing. But I would say about half of my practice, the other half, is working with trial lawyers still at the trial court level on substantive briefing, motion practice, error preservation, basically making sure that the boxes that must be checked in order to appeal later, if you need to, or if the other side appeals something that was favorable to you, mm-hmm. making sure those boxes are checked so that those rights are preserved. Also, just the briefing, the research, the strategy, a lot of the things that sometimes trial lawyers aren't as focused on, or they don't want to do that. They want to be focused more on discovery, telling the story of their case. So what's really nice about it is, I will brief summary judgment and argue it, and maybe even go to trial and sit second chair. And while the trial lawyer is putting witnesses up and talking to the jury and telling the story of what happened to their client, they know that I'm sitting there preserving error, making sure those boxes are checked, making legal arguments, arguing about what needs to go into the jury charge that goes with the jury so they fill out their verdict at the end of the case. And so it's kind of nice because it lets you kind of divide and conquer
Mm-hmm.
because there's so much. I mean, there's so much to keep track of when
Mm-hmm.
you're in trial, and it's a lot for one person or two people, and so it's kind of nice to divide up that labor.
You're watching JP Kathy and the Crew Network. You can watch JP Kathy and the Crew between 7:30 and 9 Monday, Wednesday, Friday. You're watching The Lawyer Show. We're on between 12 and 1 on Thursdays. So to your point, what you want to make sure that you're doing and is at the trial court level, right? We're still talking about the judge and the jury and all that stuff. To bring on a Morgan McPheeters at your trial level is probably reserved for some pretty big cases, I'm guessing.
Yeah, I mean,
And I need to tell everybody too that you are the 2018 John Howie Award winner
Yes.
for the Dallas Association of Justice.
Dallas Trial Lawyers Association.
Dallas
Yeah.
Trial Lawyers. Okay, so you've got that.
Thank you.
But the because the reason is that a lot of these cases, if I'm a plaintiff's lawyer and I think I'm going to get a big verdict against a big company, I know they're appealing it, and Texas courts is a very dangerous place for plaintiffs. I mean, we're talking about a state of politicians, almost all of whom I say that, but many of whom have gotten elected, basically promising to cut out the frivolous lawsuits. And
Yes.
by frivolous, they really mean all lawsuits.
Yeah, you hear that the term frivolous lawsuits. You hear that a lot in
Mm-hmm.
Texas, and tort reform.
Tort reform, and so these are companies, and these are, if you take a big verdict against a big company, there's an excellent chance you're going to get appealed. And so really that plaintiff's lawyer, by bringing you on, is thinking 3 steps ahead.
Yeah, and a lot of times with a smaller case where you're dealing with a car wreck with a minimum liability policy, it can be cost prohibitive to bring in appellate counsel. It just is, and it's unfortunate too because the issues that come up in big cases, they often come up in the small ones too, and it's sometimes no less complicated, but it makes it cost prohibitive to come in. But the flip side of that is what makes my practice really interesting and fun is that I do tend to get hired on bigger cases, more complex cases, so it's always something weird. I'm getting brought in where there is some funky issue, there's an undecided issue in the case law, or there's a really strange fact that throws a wrench into things. So that definitely keeps it interesting.
Mm-hmm.
I spend a lot of time researching, writing, reading, but it's at least always something new, something interesting, something weird.
It's the weird stuff that makes it in the door.
Yeah. Yeah.
I mean, and to get in front of the Texas Supreme Court too, you've got to have a really, to some degree, a quirky issue, because what the Supreme Court is trying to do is they're trying to harmonize. We have 14 circuits?
14 courts of appeals.
14 courts of appeals in Texas, and some of them have ruled differently on the same issue.
Yes.
And so it's the Texas Supreme Court's job to say, well, okay, this issue is cropping up, and Corpus Christi is not agreeing with Eastland, and Beaumont is not agreeing with Dallas, and the Supreme Court, we need to set this one issue straight.
Yes.
And it may be an issue that is a bunch of maybe a weird issue that the litigant may not think is that important.
Yeah. I mean, oftentimes when I am trying to explain to folks, hey, you just argued. What was your case about? And their eyes kind of roll backwards because I'm like, well, okay, I represent 2 guys who were electrocuted on the job. Okay, wow, that's interesting. That's compelling. But then to really explain what the case is about, I'm getting into the nitty gritty of Section B2A of a statute, and people are like, I've lost you.
The client's like, but they didn't feed my dog.
Right.
That's why I should have won this.
Yeah. So it is. It always comes down a lot of times to statutory language, interpretation of that. Like you said, if you've got a conflict amongst the courts of appeals, that's a good way to get the court's attention on a case. But you never know.
So let's talk about the case that we did together.
Mm-hmm.
Okay. I don't know how much of it I can reveal on my end of it. It was a fun trial, but
I think anything that's in our Supreme Court briefing that's public, I don't know, maybe not.
A lot of the details and the facts of my trial didn't make it.
Right.
I mean, because that was sort of incident. So I'll avoid that because it was expunged.
And it's some of the best
It
stuff.
was expunged
It
due to your hard work. So okay.
Some of the most fun facts we can't talk about.
Some of the most fun facts. Yeah, trials like these, they don't grow on trees. No, this was one for the ages. It really was a lot of fun. So I'll give the lead into it. So what happened was I acquitted somebody because, again, more lawyer push-ups, right?
Yeah.
I do criminal law, and I acquitted somebody on some pretty severe charges, some pretty serious stuff. And so I took the case to trial, and then we got a not guilty verdict. And then actually kind of even somewhat inadvertently, we filed I say inadvertently, had I seen the issue beforehand, I might have just agreed with the state and said, oh, well, this person's not eligible. But my paralegal at the time handled those. And so what we would do in those instances is to file what's called a petition for expunction, which erases the arrest. And under Chapter 55 of the Texas Code of Criminal Procedure, which Morgan probably knows a lot more about than I ever will.
Like, here we go, statutes.
Yes, PTSD. So under the Code of Criminal Procedure, you can have, if you win a case, you basically, with a lot of exceptions, you can get it off your record. And 95% of appeals are expunctions are very straightforward, very either entitled to it or you're not, very cut and dry. 5% of them are ridiculously hard, the remaining 5%. And so the issue was that they had executed a warrant against my client got arrested for, we can say the charge, right? It was because that was in the pleadings for the Texas Supreme Court, right?
Yeah. Yes, it was. And her name was abbreviated. And
her name is abbreviated.
The details
yes.
of the arrest and the charges were in the record, but not her name.
Right. So the what happened was that my client had been arrested for aggravated assault with a deadly weapon, and so they were arrested right then and there for that offense, for aggravated assault with a deadly weapon. Police get called. They take her in. They put him in handcuffs. May or may not be a her.
May or may not.
I may just refer to random people as her or she, like a boat or a ship.
Yes.
Right. So
they. We'll go with they.
They. So the police arrest them on the spot for that offense. This person also had, just coincidentally, a warrant for their arrest for a theft that had occurred 2 years before.
Yeah, several years back.
Several years before, and so the police executed the warrant for both.
Yeah, they run this person's name. They see this other thing come up. Hey, we're arresting them. We'll just lump this together.
We'll just do this together.
Yep.
Another lawyer gets appointed to this person's misdemeanor case, runs down to the courthouse, pleads them guilty, and that case was done.
For the old charge.
For the old charge, and that was done. I handle the new case, and I win it. And so the question is, do we get the arrest off of this client's record? And the prosecution's point was, no, you don't, because the arrest was valid because of that first one. And our point was, well, that's ridiculous. Now everybody in the world who looks up my client is going to see that they were charged with aggravated assault with a deadly weapon, which we won.
Yeah, a jury decided not guilty,
right.
Which is a big deal.
We took this to a jury, and a jury did this to it. Because I went to trial and did a lot of name dropping and talked about how long I'd been practicing law to the jury. And it was not in Tarrant County. So there's that.
They were like, wow.
They're like, wow, you guys are so friendly here. So that was the issue was, and so the prosecution objected. We filed, my paralegal, I had her file a petition for expunction. Had I known ahead of time that and we just didn't realize it. We just well, we won this case. Let's go file it. Let's go down to the courthouse and let's file it.
Makes
and so
sense.
it was a very, very small detail about the previous arrest, which we never crossed our mind. And so the state says they flagged it and they said, no, we're not going to agree. We think that that you're not eligible because we think this arrest was valid, and we think that chapter 55, right, was what the whole debate was about, right? So we think that chapter 55 says this. And typically the prosecution on things like that, they get their way because they're the ones who agree to it. And for a litigant to take this all the way to the Texas Supreme Court would be, they've got a lot of leverage.
Yeah, and it's part of the reason why the case law was pretty lopsided. And so the basis for the state's argument that this person should not be able to expunge was because just about every court of appeals in Texas had agreed with them that when you are arrested on the same day at the same time for two unrelated offenses, and if you plead to one and you're acquitted of the other, too bad, so sad, because it happened to be the same day, you're not eligible to expunge either. And so they had convinced courts all over the state that this was right. And the expunction statute is kind of a bit of a Frankenstein statute. It's got lots of issues with it. It's got some language that's not super clear. And so over the years, the legislature, they keep trying to fix it, and in some ways maybe just keep making it worse. It's just kind of a mess. And the way you end up, though, with this really kind of lopsided case law in favor of the state as opposed to acquitted individuals is, like you said, the state has all the resources in the world to appeal whenever they want. And so if you get an expunction, like in your case, they just say, okay, giddy up, we'll just go ahead and appeal this. Whereas most folks that seek out an expunction, they barely have enough money to even pay for the expunction itself.
Right.
They don't have enough money to hire a lawyer to brief and argue at the Court of Appeals. And then when the state appeals that to the Texas Supreme Court, to brief and argue it there. That's extremely expensive. And so a lot of times what we found in researching these other cases is that the defendant wouldn't even really show up when the state would appeal it. There's no brief filed on their behalf because they just don't have anybody. And so you've got the state making their arguments, and the courts of appeals just kind of go, okay, well, that makes sense. We'll do that then.
Yeah. Yeah. We did, and that was one of the issues in our case. I did the expunction for free because we do them all the time, and because we're just helping out this client that we just climbed this huge mountain for this client, and we got to the top. It's like in Baylor terms, kicking an extra point, right? Or that's Texas A&M Aggie terms right there, kicking the extra point, because football is really important in College State. Okay, so we told her we were going to circle back.
We came back.
And yeah, we did. So we filed this thing. We did it for free. And then we run into this crazy issue of and so the prosecutor objected through the flag, and I was like, oh, damn it, I think they're right, and oh well, we'll see. And then I take a look at the statute, and I'm like, no, I think we're right about this. I think we're right. I think that the way that this statute reads, I think that we get this off our record. And we took it to Judge Wheelis, who at the time was because we can talk about this too. This is obviously on the record. We took it to Judge Ray Wheelis in the 366, and it's kind of funny. We stipulated all the facts I stipulated all the facts with the prosecutor because there was really nothing we're arguing about. It's a straight legal point, so there's really that's why none of the good facts from the trial made its way onto appeal. Had I been thinking about it, I probably would have, to give you a little more ammunition going forward.
Make it a little more juicy.
But a little more compelling as to why our client was deserving of relief. And so, and I remember Judge Wheelis, who I love Judge Wheelis to death. He was the first judge I was ever a prosecutor in front of. And as promised, we're name dropping. And Judge Wheelis, I remember he was kind of clowning me a touch at the beginning of the hearing. He was like, yeah, of course they're right, Jeremy. They're the prosecutors, and they do this a million, And we had not only that, but we had the probably one of the head expunction lawyers in the state was a Collin County prosecutor at the time, Andrea Westerfeld, more name dropping.
Yes, she had written.
She wrote
all the books.
Yeah,
about
she wrote the book at it, and she's a phenomenal lawyer, and I still call her to this day. And when I have a question about expunctions and non-disclosures, and she's not in Collin County anymore, but we took it. But Wheelis was kind of laughing at us at first, and then he was like, "No, I think you're right too, Jeremy." And he says, "I'm gonna grant this," and so he granted the expunction. They told me instantly they were going to appeal. And I basically, I reached out to my friend Thad Spalding, who you used to work for, and I said, "Hey, Thad, I think you got an issue of first impression." Mm-hmm. Explain to the jury what a first impression is, because you're the Supreme Court.
Issue of first impression. That's a question based on a statute or, any number of things that has not been decided before, and so it's kind of fun because as a lawyer you get to just see what you can come up with based in the law, see what's out there that supports your position, but it's an open question. And so for courts that's compelling. Mm-hmm. They're like, okay, we've got a question that no one's answered before. We need to get to the bottom of this.
Yeah. And Dad said, this is he looked at it and he said, "I think you're right." And he said I'm not nerdy enough. No, I'm sorry. I'm not.
I've got this girl working for me.
I'm not cool enough of an appellate lawyer, because you're, as the cool one. So you take it from here. I have suffocated enough of the lawyer show today talking about myself and things that don't matter. So I will let you take this to the finish line on the appeal.
Yeah. So Thad took the case and he handed it to me and said, "Here you go. Let's figure this out." And we worked together a lot on it, but like I said, we had basically every court of appeals stacked against us and had to find ways to distinguish all these cases. And it was kind of mind-numbing because the cases all, the names of all the cases are people's initials. And so they all just kind of blur together in your mind. But yeah, we came up with this argument under principles of statutory construction, which are the rules of how we interpret statutes in Texas, that the state was wrong. That when you are acquitted of a crime, period, you are entitled to have that expunged from your record. And that makes sense. And part of the problem is that expunction is a statutory right. It's actually not a constitutional right, which kind of stinks and seems kind of counterintuitive. But it makes it, the effect of that is that it's harder to get that right squared away because it's not constitutional. It doesn't carry as much weight. And oddly enough, too, side note, is that expunctions, although they are obviously extremely related to criminal procedures, it's a civil procedure.
Mm-hmm. That's why it was in front of the Texas Supreme Court.
Right, yeah. Exactly. So that's how we came in. So we briefed it and argued it in front of the Dallas Court of Appeals, and they went with us, and we won. So that was really exciting and surprising because I think we all kind of went into it going, hey, this is an uphill battle, but we'll give it a shot. We think we're right. And we won. So that was really exciting. And then the state turned around, filed their petition for review, and the Supreme Court asked for a response. So we said, okay, here we go. And then they asked for a merits briefing, and then they set it for oral argument. And again, Thad is such an awesome lawyer, and he's such a great mentor. He's like, all right, you're up. You're going to argue it. So that was my first argument in front of the Texas Supreme Court. It was so nerve-wracking and stressful getting ready for it, trying to, I had like a chart of all these cases that I was trying to reconcile.
So yeah, what do you do to prepare to argue in front of the Texas Supreme Court?
It depends on how long you've been living deeply entrenched with a case. If it's not as much in there, you've got to start prepping fairly early. It's stressful because you are standing in front of 9 justices who can ask you about anything at all. Any case, you may or may not have read it, you may have not caught it, and they can ask you about it. And they can pepper you with questions. They can interrupt you. I personally prefer what they call a hot panel, which is a panel of the court that's asking a lot of rapid-fire questions. It's a lot easier than giving...
It's like the lawyer show.
Yeah, exactly. What do you think about Aggies? Tell me now.
What's your favorite statute? What is your favorite rule of civil procedure or rule of appellate procedure?
My favorite rule of appellate procedure, the one that allows for motions for extensions.
I am stunned that you have an answer for this. I promised there's a lawyer in our office, former lawyer show guest Kyle Terrian, who handles a lot of criminal appeals. He said, ask her that. So when you argue with the Texas Supreme Court for the Texas Supreme Court, you were saying you prefer a hot panel. Was it a hot panel on the one where you argued with us on our case?
Yes, it was. And it's better to have a hot panel than a cold panel. A cold panel, they're just staring at you. You can't, you don't have a clue what they're thinking, what they're getting at, what issues may or may not be tripping them up, where they need questions answered. So a panel that's engaging with you, you at least kind of can tailor your argument in answering questions to try and help them so that they can help you.
You can connect more easily.
Yeah.
So you're not like to Justice Hecht. You're not like, hey, Nathan, here. Hey, I'm here.
Right. And it's awkward to get up there and try to give a speech. That's not very compelling. So if you're just trying to recite something, I mean, that's rough if a panel is quiet. So I prefer a hot panel. They were pretty hot for that argument. Again, we really just didn't know how it was going to go, but it was a unanimous decision overturning all of those other courts of appeals to the extent they disagreed, and we won.
And it is probably today the preeminent expunction case in the state.
I think that there have been, at least as far as acquittals go, because the statute, as far as I know, has not been amended, so they've not. We kind of wondered, will the legislature come in and try and undo or change something if they disagreed with that ruling? So far, I've not seen that. I think there have been some other expunction appeals that have made it up there since then, but on different parts of the statute, dealing with different kinds of adjudications.
That does it for the Lawyer Show today. You have watched the Lawyer Show on the JP, Kathy, and the Crew Network. I am your lawyer, Jeremy Rosenthal. My co-counsel today, Morgan McPheeters. I hope that we have answered all of your questions and then some. And again, if you are at home and wanting to be a lawyer, go to Baylor. That's fine. You get
a ringing endorsement.
You'll get practice court and a good job, and at some point I'll probably be your client. So anyway, thank you guys very much, and we will see everybody next week.
Thanks for having me.